Well, good afternoon, everybody, and welcome to this session on ethical considerations of a wrongful termination claim through the lens of the virtual world. This particular session is going to focus on primarily the ethical issues that the parties are being faced with, or the arbitrators, the discovery issues, challenges at the hearing, and all through the lens of the new world virtually that we're all in at this moment. I'm Jan Holdinski, and I am one of the vice presidents here at the American Arbitration Association. And my colleague, Schmidt, is one of the vice presidents at the American Arbitration as well. We are both in our Labor, Employment, and Elections division. Before I start introducing our faculty, and that will be briefly, I just want to let you know that we will entertain some of the questions, but we do ask that you put them in the chat box, and we will go through them as we move forward with the program. So today we have three very experienced faculty excuse me, with us. Catherine Farrell is an attorney at the Pierce, Farrell, Tafelski and Welch law firm. And today Catherine is going to be bringing the perspective of an arbitrator. And then we have Heidi Sharp, who is an attorney with the Sharp firm. And Heidi today is going to be bringing the perspective of the plaintiff attorney. And Anne-Marie Vercruysse Welch is an attorney at the Clark Hill law firm, and she's bringing the perspective from the management to the table today. All three are very experienced employment and labor attorneys. And we look forward to the exchange of information that they're going to be sharing with us today. Before we turn the program over to our faculty, we want to see the breakdown of the group that we have with us. So in the reaction box, if you have the opportunity, just hit by a raise of hands, how many of you have the background that's primarily in the labor area? And Aaron, I think you can tally that or see like who's responding, and if they raise their hand that primarily is labor. And then we'll just assume that the rest of the group is primarily employment, academics, or arbitrators, or other.
We've got one hand raised for labor. I think I saw two hands for labor. I know we've got a couple arbitrators here as well.
Okay. So that just, kind of helps faculty, moving forward with their comments in that. But at this point, I'm going to go ahead and turn it over to Anne-Marie.
Hey, thank you, Jan. We're so excited to be here with you all today. And I'm really excited to be presenting with my colleagues. Fun fact is that Catherine was on the very first labor arbitration case I ever had. And Heidi and I have been working together for our entire careers together on opposite sides, but civilly. So this is a scenario-based session. And as Jan mentioned, we're going to talk about, different ethical issues associated with a termination meeting that progresses into a wrongful discharge claim. We're going to talk about whether or not employees can record the termination meetings secretly or not so secretly, all of the challenges we've all faced with virtual discovery, and then the challenges faced in conducting a hearing virtually as well. Again, we really welcome your Q&A. Put it in the chat, and if there's time at the end, we'll do Q&A then as well. So let's get going with our scenario here. Okay, we've got Susie Smith. She was a 10-year employee of WFH Corp. And during her tenure, Susie was a diligent employee who received meets and exceeds evaluations and was well liked by her coworkers. Due to state COVID mandates in March 2020, Susie and her coworkers were sent home with their second monitor, laptops, work chairs, and for the lucky few, their standing desk. Susie did her best to keep up with her work at home while overseeing virtual school for her 9-year-old twins and trying to mute herself on Zoom every time her dog barks. This sounds eerily familiar. Sitting in her fuzzy slippers, button down and pearl necklace for her umpteenth Zoom meeting of the week, suddenly Susie noticed that a new meeting had been added to her calendar, the ominous meeting with HR for Friday at 2 o'clock. Susie couldn't imagine what this was about or why her boss hadn't mentioned it on their weekly Zoom-alongs, where everyone got together and talked about what their new pandemic baking they had done to keep everyone connected. Susie was a little suspicious about the meeting and decided that even though WFH Corp had a no recording policy, she was going to record the meeting from her phone just in case. So on Friday, Susie zoomed in and saw her HR journalist that she had never met come on the screen, and then her boss's boss. She hardly knew her boss's boss, but thought he liked her and that they got along well. Taken completely by surprise, she was told that it was her last day at WFH Corp. With the changes taking place during the pandemic, her position was eliminated. They wished her the best of luck and told her that a UPS label would be arriving for her to return her laptop, phone, and any files she took home. They let her keep her chair and any extra office supplies. Upset, Susie packed up the items the next day and sent them back to the company. The next week, Susie joined her former coworkers for a Zoom happy hour to lament about her lost job. Expecting to hear about scores of others being let go due to the pandemic, Susie was surprised to find out that they knew of only one other person that was let go. And they had already been alerted about a new hire starting the next week who'd be doing many of the same things Susie did in her job. Her friends, mostly childless people who were riding out the pandemic in various B&Bs with great views, told her how much they would miss her, but that maybe this was for the best, so she could spend extra time with her kids. At the next Zoom happy hour, Susie found out that the new hire was a 20-something male with no kids. Though he had a different title, they all talked about how he returned emails at all hours of the day and night, and they thought he would be great to work with because he was getting so much done. Hearing about her new replacement made Susie think that maybe her job wasn't eliminated after all. After weeks of no job offers, Susie reached out to an employment attorney to talk about her situation. Just as her new counsel was about to send a demand letter to the company, Susie received a certified letter in the mail from WFH Corp. After Susie sent her laptop and cell phone back to the company, they had their IT department conduct a forensic exam. What did they discover? They found out that when Susie was working from home, she had emailed her personal account her entire contact list, which included the contact information for customers and prospects, deleted a number of company files from the system that contained material information about past customers and vendors, chatted via the company instant message system with a coworker about doing work for a competitor as a consultant while performing work for the company, and revised and updated her resume during company time and sent it to various recruiters before she was terminated. Susie brought litigation against WFH Corp, claiming her termination was in violation of Title VII because she was a mother of a school-age children and was replaced by a younger, less experienced childless male. In turn, WFH Corp countered Susie for violations of its confidentiality, non-disclosure, and non-competition agreements. The courts are still closed, and the entire case must be litigated virtually. So that was a whole lot to unpack. So let's summarize it really quickly. Susie was an above average employee who had been working at the company for 10 years. She is a mom and has 9-year-old twins. She was told that her job was eliminated. She recorded the termination in violation of a no recording policy. Her former coworkers told her that she was replaced by a younger single male. And the company learned that Susie violated her non-compete agreement by working as a consultant for a competitor. The company also learned that Susie sent proprietary information to her personal account and that Susie stole time from the company to update her resume and apply for a new job. Sounds like there's going to be a lot of ESI involved in this one. Okay, so my job is to talk about what went wrong at the termination meeting. Remember, the company had a no recording policy, and Susie went ahead and recorded the termination meeting. The first question that comes to mind is, can employers lawfully ban recording under the National Labor Relations Act? Okay, and my answer is, it depends. I'm a lawyer, right? It's got to be the right answer. You can have a no recording rule currently under the Boeing case, so long as you can show that there's, some good reason for having it. Like, for example, you have proprietary and confidential information that employees could potentially record and share with others. In the Boeing case, Boeing was allowed to ban all devices with cameras, which would include an iPhone. Okay, we know that employees can take voice memos without taking pictures, but still, that's what the NLRB said nonetheless. I think that could change once the Biden administration's NLRB members get confirmed, maybe in December timeframe. But there are exceptions to this rule. Employees are still allowed to record if they're engaging in concerted protected activity. So if they're trying to record, say, unsafe or hazardous working conditions, or when a policy is not applied consistently, or when there's discussions about employment terms, even if the employer is the one that's having the discussion. Okay, so I think most likely here, if WFH Corp had a good reason for having a no recording policy, it could stick. Heidi, Catherine, would you guys argue that this would be an exception under the NLRA? Or do you think that the recording policy would be applied appropriately by the NLRB here?
One of the things that I always look at in recording policies is how it's being applied. So if they're looking at Susie and saying, oh, well, you can't do that in this situation, I'd be curious to know when they sent everybody home, did they make it clear that they can't be recording at home on their iPhones, on Zoom and things like that? And if it's being applied evenly and the company has specifically said that they have a reason, they're trying to protect proprietary information. For example, if she's having conversations with her coworker regarding whatever she was selling for WFH Corp, right? And that's a item that's in the competitive market. Of course, they have a good reason not to have those conversations recorded and potentially accessible. But if this is the first time that they're going to be applying that particular rule when Susie records at her termination meeting, that's always going to be an area where I'm going to say, well, wait a minute, this could be an exemption because she was recording based upon what she felt were her rights, and I know that you're not going to see it necessarily that way, Anne Marie, but I'm going to say, yep. And I'm going to say, well, wait a minute, this wasn't about proprietary information, and they're not enforcing the rule to protect their proprietary information. They're only enforcing the rule in this case because they think that whatever was said at that termination could be used as evidence in her discrimination case.
Oh, Catherine, you're on mute.
Yep.
I think that, Anne Marie, you're probably right. There's going to be some changes once the Biden administration gets the board in the position it wants to have with a majority of Democrats on the board. There are three kind of categories in Boeing, and I think you're really assuming that there is a rational basis for the no recording policy, it's probably going to stick. But, I think that as an arbitrator, I'm thinking that Heidi's view of, how is it being applied and what are the circumstances in this case, all the details of that are something that we always have to take a look at and focus on. So it's all in the details.
And with my employers, what I instruct them to do in termination meetings is ask right up front, are you recording? And make sure they're being truthful with you by make them show you the phone if they're coming in, and put it in a basket. Everybody puts their phone in a basket potentially, or to show the phone if virtually. Doesn't mean they don't have another device on them that they could record on, but it's a practice that sometimes we utilize. Now, the next question is, without there being a rule, let's pretend here there wasn't a rule, can the employees record without the consent of the employer? Right now, we're all based in Michigan, where we just learned that the Michigan Supreme Court has decided not to take up the question of whether or not Michigan is a one-party or two-party consent state. We have an old Michigan Court of Appeals rule that says that we're a one-party consent state, which means that if so long as you're part of the conversation, you can record. And then we have a new Eastern District of Michigan case that says that you have to have consent from both parties to record. I think the answer really depends on what location that you're in and what state rule applies here. But I would argue that without the consent of the employer, the employee should not be recording the meeting. Okay.
I will say here, this is an area where for years I have advised to record. And Anne Marie and I have had this discussion back and forth a few times, and until this new issue came up in our Eastern District of Michigan, and then recently the state Supreme Court didn't take it up, it had been pretty well accepted that we were a one-party consent state. And I've had people say to me, oh, I just looked up on the internet, or I know, or what can I do? And for years, I've given the advice freely to record without consent if you choose to do so. And it used to be, of course, this is how long we've been practicing now, you couldn't record on your phone. So I'd even tell them to go to Radio Shack, of all things, and get the little recorder and put it in their pocket, and they'd all be so proud. Oh, it worked. And I know I'm going in to be terminated. They called me to HR today, and they practiced recording. And I've had lots of tapes that I've submitted into evidence. And now they're all phone. And I remind them, this is digital. It's a different world. So if you're going to do it, you got to get it beginning to end and do this and do that and send the audio right away and don't play with it. But for a long time, that's been, I thought, easy advice to give, and it's changed now. So we'll have to see what happens next.
So what advice would you give now?
Well, now, as I told you yesterday, I think that we are still a one-party consent state because the Supreme Court didn't take it up. I don't think that they've changed what we've been doing before. I think if we have a Eastern District of Michigan case where I file, let's say, a discrimination claim, I expect to see from someone, one of your colleagues, a motion, and we're going to see, what happens with that opinion, and if the bench in the Eastern District of Michigan follows suit or not. But until then, I don't have a reason not to tell them not to record. I will say a little different from what you've experienced recently is I had a client who wanted to record, and he said, because he wouldn't let my attorney in, and they said, okay, it was the battle of recording. Everybody put their phones out, everybody hit record. And he said, and the management side said, well, there's nothing I'm going to say that's a secret. So let's all record together. And it was like, hey, why not? If what you're going to say is, you stand behind it, why not let them record?
Yep. And I have had recordings work in my favor. It really depends on the client that you know and the client that you trust. It just depends. Now, Catherine, if this was in front of you and I argued that that this was recorded unlawfully, and Heidi argued that it was recorded lawfully, what would you do as the arbitrator?
I think that I find the Eastern District decision and its analysis of the plain meaning of the statute very persuasive. However, because the Supreme Court didn't take that, and because we have 2 Court of Appeals cases, and I think that the standard is pretty clear that it's a one-party consent if you're a participant, that I probably would allow that evidence in. And part of that is because an arbitrator can parse and view things a little differently, and you want the parties to be able to get all their evidence in. And so I probably would take the view that the recording could come in unless there were some very special and unusual circumstances.
And I would argue strongly in front of you otherwise, but that's okay. You know, one of the things that I recommend employers do if they really don't want recording as well is to take off the ability to record as a host on Zoom. And that's something that you can do too, because you know they can press the button as well, just as another fail-safe. Another issue that came up is whether or not an improper recording could be used as after acquired evidence. And I think that we have, you know, Catherine's take on this from an illegality standpoint, but what do you think from the standpoint of violating a rule?
Well, you know, assuming that there's a strong rule and the rule makes it, as I think it might, through the Boeing analysis, I think that the issue of getting that recording in and after acquired evidence, of course, that goes to usually the issue of damages and where the, you know, where you're going to parse and break a matter. So I think that assuming that it's improper as a result of a rule, as after acquired evidence, I'm not sure where I would go on that one, frankly. I'm going to hedge that one.
Okay.
Let me throw something in there that might help you later, Catherine, if this comes in front of you. If this became an after acquired evidence issue, the first thing that I would do is ask for expansive discovery on how often they have enforced this rule. Because before everybody went home for COVID and before Susie got there in front of Zoom, you know, she was in office where everybody carried in a phone every day with a camera and a recording device. And I bet they're taking pictures, and I bet that they were recording cute videos and doing all sorts of things. So Anne Marie knows she's going to get a discovery question from me, and I want to know the name and the identity and the position of everybody who'd ever been terminated for violating that rule before. And, you know, if they hadn't been terminated, had they been disciplined, how do they enforce it? What did they do? Do people take, you know, are they dropping their phones in as they go into work? We know they're not. So, you know, I'd really want to see if this is an after acquired evidence issue, and this is a rule that you're saying was so badly broken, we would have terminated anyway. I want to see all the other people who were terminated for that rule. So, and then of course, in COVID times with Susie, you know, what are they, did they disable recording on Zoom when they gave everybody access? So, you know, we're going to want to, that would be a way that I'd push back on that for certain.
Well, I think, you know, it always depends on all of the details. I mean, all of these issues depend on all of the details as they come out. And you make.
We can argue about this all day, but I know we have to move on. One final point on that, Heidi, though, is that the employer can only discipline when things come to their attention. So I would argue that as well. So Heidi, why don't you take us through the challenges of discovery in the Zoom world?
Yeah, so we call this zooming into discovery. I jumped into discovery in the Zoom world like I think so many other folks did. I have primarily plaintiff employment cases filed in both state and federal court, and I have a couple of arbitrations going. So I've done it in the gamut of rules that might apply. Our first two bullet points kind of go together. So first, how do you deal with ESI in the virtual discovery world? And then also, how do you ensure that proprietary information is handled? I think that both of those, the ESI can have a lot of that proprietary information. For me, gone are the days when I either get many boxes delivered to my office and then I flip through it and highlight it and tab it and then ask my client to come in and say, hey, can you look at these documents? I think they're important. Tell me what you think and what else do we need? That was probably ended a period of years ago, but of course, over time, it still happened often enough. And luckily, no banker's boxes have been delivered to my office lately. But what you still get, though, is a link, right, to a secure link. And they say, here's all of the documents that are responsive discovery. And you open that link and it's 1 to 300, 600, or 10,000 documents. When I realized we had to do this from home, for me, not too much changed because the ESI, but what did change, I noticed, was more from the people on Anne Marie's end, that they didn't always have access to their systems when they went home for the documents. And so we had to craft sometimes some interesting requests as far as ensuring that we got what we needed, that the people who were in certain companies who needed to get past for example, their firewalls, or ensure that the information was transmitted properly. And what I did was right away do some research on how to transmit documents securely so that I could get what I needed, review it, and then ultimately get it to my clients. So that's ability to access and providing access. So what my office uses is a certain software. So when somebody like Anne Marie says, hey, I can send you this, here's 2,000 pages, but they're all proprietary. I'll tell you, one of the things that overrides both ESI, exchanging discovery, and depositions, and we'll talk about, is a protective order. And a protective order is going to come up in almost every employment case I've ever had for many reasons. On the side of the employer, they don't want the information that I'm asking for regarding their employees, their process, their proprietary information, what they do, what they sell, how they do it, out in the public. And of course, we all know if you're not in arbitration, you're in an area where this could be in the public realm. And so we have some pretty standard orders that we use in Michigan in the state court. Most of us have a standard order that we've read many times and are used to. In the federal court, it's similar. And I now also have a pretty standard one that I use, of course, in arbitration processes. I have revised those and updated them, as I'm sure Anne-Marie has, throughout this whole COVID Zoom time. And we now include a number of things that have been helpful. One of the things that I do is that I ensure that if I'm sending either my client's information, which usually includes their medical records, past employment history, it can include criminal history if it has that, you know, very private things that they don't want to there either, that I want to talk about specifically who has access to that. And if that person, the party, their representative, their counsel, whoever it might be, is going to be in an environment where that information could be accessible to others, I want to know. And I know it sounds like, well, wait a minute, they have their own obligations, and they do. But if somebody is primarily and only working from home, you could be in a position where their partner and them share a computer or a desktop or information. And you want to know that this isn't information that somebody's printing off and is sitting there and is now accessible, because, you know, previously you'd have people in an office environment and you know that those obligations and those firewalls are, you know, better. And it's the same thing with my clients. I've had people say, well, wait a minute, is this going to be in their home? Or can they access it in their home? And I often have people where I'll say, well, they're not going to, you know, what we'll do is I will transmit it on a secure link that's only viewable, not printable. So they can go through and view it and say, oh, these are the certain pages that I think are important. And then I can print it on my end and discuss it. But similarly, when I'm transmitting information, I'll say, well, who's going to have it and where are they going to have it and what's your use? And I think that's an early discussion you have to have. And those things can go into that stipulated order, because you want to be in a position where you're saying, hey, this isn't going to a Gmail, Yahoo, Hotmail account unaccompanied by a secure link. I think, you know, that link can solve a lot of problems because it tells you who gets it, what's on the information, when it's viewed, how it's accessed. And if you give them the permission to download it, you can see all of those things through these programs. And they're very simple to use. Similarly, I, of course, during heavier COVID times, unfortunately, luckily we're turned a lot of corners here. I didn't have the ability to have a plaintiff come to my office and drop off their pile of personal information, which in my practice is very standard. I say, okay, discovery is coming up. And I used to give them a laundry list even before discovery answers are due of, you know, tax returns and medical records and things like that. Well, when they couldn't physically get there, I said, well, I need you to get it to me electronically. And I ensured that my office had the ability to send them a link, because most plaintiffs aren't going to have specialty software or the knowledge of how to do this. And when I sent them that link, they could upload it just as PDFs or Microsoft Word documents or whatever it was, because most people do use their home email as Yahoo and email and things like that, and they're not secure. They load it up, and then my office could get it on our secure server, download it, see what was there. And I knew then that their information was being transmitted, because similarly, I have an obligation to ensure that their information is held securely. So when we're looking at the ESI back and forth, I think you have to think creatively, and you have to think, what's the end game here? You know, I know why I'm asking for certain things. And one of the things that I think works the best in these situations, frankly, is communication. I am never too, big on myself about, I have no problem picking up the phone with my, opposing counsel and saying, I'm going to be sending you discovery requests. A couple of them you might think I'm just asking for it on a fishing expedition, but I'm not. This is what I'm looking for. This is why, this is how we're going to secure it. I'm sure your client's hesitant to give me that. So let's make sure it's built into our protective order, and we can revise that and ensure that's there. And I say that here, is the standard protective order enough? It might be. And if it is, use it. Use what you're comfortable with, use what you have there. We talk about what are you going to do if the information is going home? Well, you can ensure it only is viewable in that home. And then ultimately, what do you do when you're done with the information? What I've done recently, and I think it's helpful, especially, when you're across the aisle from somebody that you know well, is I say, well, I'm going to have, if a plaintiff has access to hard copies, and I will do this also to ensure both my plaintiff's obligations are met and my obligation as counsel is met, I'll have them physically bring it back to my office, and I'll just drop it in the shred box myself, like gather everything up regarding work from home corp, you know what I mean? Everything you did, it's a closed door, your case is over, you're done, we have this order we have to comply with, and I'll have them physically bring it to me.
Heidi, do you have them certify that they haven't maintained any copies?
I will on occasion, and most plaintiffs I don't have that problem with, but for example, in this case with Susie, we know that the defendant is going to be particularly sensitive to copies, to documents, to downloads. What does she have and why? And I'm sure you would have asked her during her deposition, what does she have? What did she do with it? Where did it go? And one of the things I haven't even touched on in discovery that we see a lot and got very hard during COVID times is physically having cell phones and laptops, examined by a third-party IT company. That's come up, and we wrote this, and because it was a situation that we've both seen and we've both been a part of. And what happens is, of course, have somebody who's in that situation getting terminated. And it's happened with me a number of times where the employer has said, well, we have bigger issues regarding the documents, her computer, her laptop, all of those things. And normally pre-COVID, first thing that would be asked is, let's send that out to be examined. Well, for a while there, it was, hey, you have a person who doesn't want to let go of their cell phone, and so you have to figure out how to get that to that third party with them getting it back. So if those documents do need to be destroyed, I will. And sometimes, I've had clients ask during their deposition, if you gave those back, have you given everything back? Is there anything else? Do you have a storage unit? Do you have these other places? And if they, for example, had documents on a USB, I have often taken the effect also of gathering up all the USBs and sending them back to defense counsel. Because at that point, there's no reason that I need them, nor do I want them. And I want to ensure that both of our obligations are complied with.
Heidi, one other question real quick is, do you put in your orders, because it's something that I'm starting to do when people are working from home, is that when they're working on this case, and if they're on the phone or whatever with co-counsel, that you need to turn your Alexa or your Google Home devices and all of that off if you're talking about our confidential information?
So I've never done that, but I have to admit that's why I don't have one at home, because I know that it can record. Anne Marie and I are very similar. We're both married to attorneys. And I'm sure that there's conversations in your home that you'd never ever want recorded. And we're very sensitive to privileged confidential information. I've never run into that one, but I will tell you, I realized how important it is during a Zoom mediation. My client thought that they were muted and started chatting with somebody on the phone. And I said, whoa, you're not muted. But I also realized that they probably weren't keeping their obligations of confidentiality as, they weren't holding them as important as they should. So, this has been such an important reminder and kind of a peek into how both of our parties interact and relate, because I've been able to see on the other side. And I'll tell you, taking depositions where you see, for example, an HR director in their home, I understand how incredibly private your home is and how that must be incredibly inconvenient, and they never want it to be deposed in their home. And I try and be really sensitive to that, but also it reminds me that if they're sitting there in their kitchen being deposed, you need to know who's around them. Before I move on to Zoom depositions, which is really a part of that, I did want to ask you, Anne-Marie, other than some of those things I talked about, what are you including in your orders and what are you doing across the aisle to say, hey, this is what we need to address?
Well, I think that the most important thing you talked about and you hit on it is every case is a little bit different and the information that you're going to obtain is a little bit different. And so unlike before where we would send out standard orders, I think now you really have to work collaboratively with your opposing counsel to come up with creative strategies to make sure that you keep that information confidential. And there's no one size fits all protective order anymore. And I think we both understand that. And I also think incorporating the ESI rules from the federal rules is helpful as well from the federal orders, the model ESI rules.
Yeah, most of my model orders are from federal court, and it's been helpful. Even in AAA cases, most, whoever is across the aisle with you is usually familiar with them. And if you weren't in AAA, is usually would be a federal matter. So it's, easy to do that. Moving on to those Zoom depositions, Susie's case a couple months ago and even now would be a very typical case for Zoom depositions. And I know Anne-Marie and I feel differently about whether or not they should continue, but as long as they're here, I do think that they're here to stay. We've all talked about it. In Michigan, there's a big article, it's been on everybody's page, the Free Press printed regarding how Zoom is here to stay in our court system. From the top down, they've said that they're going to continue to use it regularly and often and intentionally. So we know that it's going to continue, and people, if you're not comfortable with it, to get comfortable with it. I think at the forefront is what if everyone doesn't agree on Zoom depositions? I would want to know why. From the other side, if it's, well, I need to see them in person. I do expect that we're going to go back to a plaintiff's deposition probably being taken in person for all the reasons it should be. And we're also, and on my side, whoever the decision maker was, I want to take their deposition in person. I want to sit across the table from them. And I frankly want to be able to ask my questions as quickly as I want to ask them without being interrupted by Wi-Fi glitching, But I find it incredibly convenient to take a lot of the other witness depositions. And here's where we really differ. By not having the additional expense to travel, it's helpful in the plaintiff's side. And it's also helpful because it's given my plaintiffs better access to their case. And Anne-Marie can tell you why on her side, it's not been as helpful.
Well, I think clients will like us to do remote depositions on smaller witnesses. And the reason being is it's cost them less money for travel, and they can easily attend from their offices because you need to have a party representative, all of that. But for the bigger depositions, the plaintiff's depositions, I think that they're going to push to do them in person. I think there is some good reason why plaintiff depositions, it's helpful to have them Zoom sometimes. For example, a plaintiff gets real uncomfortable with silence when they're looking at their own face during a Zoom deposition, and you can use that to your advantage. But from a defense side too, I can ask all the questions I want about, is your phone on? Have you closed all the applications on your computer? But I'm still real wary of, with Heidi, I trust Heidi, but with other plaintiffs' counsels that I haven't worked with before or I don't have the same trust with, I'm nervous about communication going back and forth during a deposition that wouldn't otherwise happen in person. And I'm worried about, do they have notes in front of them that, they were told to say, and, I can ask them to spin the camera around in the room and do this or that, but I think there's still ways that they can be evasive about that. And that really troubles me.
That leads into exactly my pointers. And that's why, we're on the same page about this. So whether we've got the Zoom deposition, and it kind of leads into the how to keep them from cheating and what to do and things like that. So a couple things. I would always, if you haven't already, and I'm sure since everybody who's in this today has had at least one or two opportunities to do a Zoom deposition or hearing or whatever it might be, I always say, okay, when you get there, so prior for a witness, a plaintiff, whoever it might be, I always do a dry run. I tell them to log on the day before. And when we were on work from home orders and I couldn't meet with them at all, I do all of my prep on Zoom. So they got used to having a conversation with me that way. And I would actually ask them, what are you going to wear? Where are you going to sit? Who can be present? You know, if there's somebody with children, do you have a babysitter? Do you have a dog watcher? What's happening? And I try and break down those barriers that make them uncomfortable being questioned about something in their home, right? If you're in a conference room, in an office with a court reporter, with your attorney wearing a suit sitting next to you, you're wearing a suit, the guy across from you is like, please raise your right hand. You know, you're in a mindset. It changes how you do things. And you know, I've had the chattiest plaintiffs in the world sit next to me and go, yes, no, yeah, like, and you're like, who are you? But it changes you. Well, now you're on Zoom, now you're at home, and I want to know all of those things, right? So that they're ready. And then when the deposition happens, what Anne Marie talked about is important. I will ask witnesses, where is your cell phone? Is it on mute or is it on volume? I want it on volume. And here's why. You're going to leave it in the room. You tell me, oh, I have to have it. I have children, parents, dogs, whatever. I might be called that today's the emergency. Well, then I want to know if you're getting texts, right? Because I want to know if you're getting texts, if you're getting texts from your attorney or somebody else or anybody else who's part of this case. Ideally, I ask them to remove it, walk out of the room and take it somewhere else. Kind of like, if today's the day the school is going to call, you're going to know. Because I don't want it there. I don't want it a part of it. This also goes back to what do you set up front? I know a lot of folks have been doing stipulated orders regarding Zoom decks. They disable chat function, they disable the recording function, they ensure they agree that they'll spin the camera around, they'll identify who's in the home or in the house that day with them. I'll have people go, look, I have no documents in front of me, go through all of that. And, you know, I've had colleagues who've said that the witness is doing this. No. Yes. And it's obvious, you know, at that point, remember, everything you're saying and doing, the witness is under oath. You can ask them, are you looking at your phone? Are you getting texts? Is there somebody coaching you? What's happening? Why are you doing that? Is that normal for you? Because you need to know those things. And at that point, I'd make a heavy record. Each time the witness has answered me, they've looked down. I'd like to know why they're looking down. Each time the witness has tried to answer me, they're going like this. I think they're looking at something on their computer. Is your email open? Do you have two screens? I've had folks who clearly had two screens. And I was like, what are you looking at on the other screen and why? You know, all of those things. So, you know, is that cheating? You know, I guess some other counsel might say, but you got to remember at the end of the day, when you're doing a Zoom deposition, this is a sworn under oath testimony as if you were in court. You know, however you come to that process and that procedure, just because you're on a camera, whoever's on the other side, that witness, the other attorneys, wherever they are, you know, they have taken the same oath you have to ensure that you're doing it the right way. And they have to follow the rules also. And if they can't, you know, that's when you're calling the judge or arbitrator. My answer to when do you call the judge or arbitrator is not when the witness won't necessarily, you know, follow the rules, but when their counsel won't instruct them. You know, you have a bigger problem there. And prior to that, you should have it well worked out. And if you don't, go off the record, call a judge or arbitrator and say, here's what we're looking at, here's the problem, and here's how we handle it. The last thing I'll just say, we talked a lot yesterday as well.
The problem with sometimes we've had challenges though, when that happens, having the judges or arbitrators work remotely is getting a hold of them.
Yeah.
Right.
And you can include that in your stip and order though, because who should we get a hold of and how? I was on a federal court kind of roundtable talking about it, and magistrates reminded us, you know, if you can't get a hold of the judge, call us, you know. And in the Eastern District, Michigan, we have such a wonderful bench that the magistrates often are available to answer discovery questions if the judges aren't. So, you know, and I know that might not be an option for everybody. And that is one of the reasons occasionally why arbitration can be helpful, because you might be able to reach an arbitrator quicker than, of course, either a state or federal court judge. The last thing I want to talk about real quick is cameras on or off. And I realized yesterday it's important because we all had kind of different opinions. I've been in some depositions where you've got a whole number of people on. You got, you know, an attorney questioning a witness and maybe a main attorney, you know, on the other side who's defending, and then an associate, and then a number of other people who are on because they're parties, and so they're entitled to be there. And everybody except the witness and the attorney questioning and the attorney defending now has their cameras off. I would not recommend that you allow that. I would ask that everybody keep their camera on. I'd ask that everybody else mute to prevent distraction. But again, remember, this is a deposition. You can't, if you were sitting in the conference room deposing somebody and there were 6 other people around the table, they wouldn't have hoods on their head or doing other things or walking in and out of the room. And it's life. If they're at home, they can get up and let their dog out, but they're on mute, right? And it's the same thing. You have to identify who's in the room and who they're present with. There was some examples we gave yesterday where it showed, you know, it doesn't work. You might have 3 people behind a video-less Zoom camera and you didn't even know who they were. And there they are listening to testimony that was covered by a protective order. You know, so I would always have cameras on and I'd always be very well aware of who's present and why. And of course, once you get all of your discovery done, that takes us to the actual hearing. So if Catherine wants to talk to us about that.
So my challenge today is to talk about the ethical issues involved in from the arbitrator's perspective. And so whether you're in a in-person hearing or a virtual hearing, the arbitrator's responsibility is the same, and it's to provide a fair and adequate hearing to assure all parties sufficient opportunity to present their respective cases. And, you know, as you think about that and parse that language, fair and adequate, those are kind of meaningful kinds of issues. So whether an arbitrator is the host of a virtual hearing or whether they are using a third party, the issue is to be able to ensure that there's a fair and adequate hearing. And so if an arbitrator determines that they can't do it by themselves or there isn't a third party assist available and they don't think they can do that, their obligation is to decline the assignment of hearing the matter. And that is a pretty awesome kind of responsibility if you're the arbitrator and you're going to be the host of the virtual hearing. You need to have the skills to be able to do that. You need to have the comfort of being able to use, in this case, a Zoom as the platform. There are some arbitrations, of course, where it's not being by Zoom, it's hosted by a third party. I'd like to talk a little bit also about the advantages and disadvantages of using a virtual platform. Now, the advantages, they're kind of common sense. You know, it's convenience, time zones really don't matter, neutral locations don't matter. Cost savings are probably the singularly most strongest issue of an advantage. You don't have travel expenses, and you can keep those things in control. Scheduling often is much easier because you don't have to worry about accommodations and traveling out to hotels, getting plane reservations. The hearing efficiencies are, you know, sometimes it's much easier, and sometimes, you know, there was an article in the paper recently, more than 100,000 people don't have easy access to good connectivity. So they don't have good, you know, the idea of being able to use a virtual platform in metropolitan areas is different than when you're in more rural areas. The disadvantages, there is probably a singular disadvantage. The lack of physical presence and the issue for both the advocates or counsel and the arbitrator on credibility issues. There are many, many arbitrators who feel if you can't kind of see the person in front of you in real life, then you're going to be hampered by being able to make credibility determinations about demeanor, for example. And I was in a session with Ted St. Antoine, and the arbitrators that were in this session were saying, you just have to have the, mano a mano, eye to eye. You've got to see the person. And Ted mentioned that, the research is that credibility determinations really don't hinge on whether you see a person. And there are other arbitrators, of course, who feel that virtually seeing a person on camera is a good opportunity to see a person for hours at a time very often. And so the disadvantage of not having the physical presence for some advocates, for example, comes down to how well can I push back or intimidate or control a party as I'm doing a direct or cross-examination. And another disadvantage, which I experienced today, was my main computer kind of went down in black. It went down, and good news is I have several other computers to use, but technology issues and network internet glitches can be a challenge, as well as privacy concerns. Although, for example, on the Zoom platform, I think the Zoom bombing issue has been pretty much put under control. So, next slide, please. Now, the predominant question that I wind up usually hearing is, so what authority does the arbitrator have to push or force a virtual hearing? And the AAA Employment Rule 28, which is the order of proceedings, gives the arbitrator the authority, the authority to afford a full and equal hearing and to control how that's being done in terms of whether or not there is in-person or web conferencing or telephonic conferencing, as long as you can ensure that there is a full and fair hearing for all parties. And so one of the issues is making sure that all parties have the opportunity to present their evidence to the arbitrator. And the arbitrator, of course, is the person who determines material and relevant evidence. So Rule 28 of the employment rules gives us full authority to the arbitrator to determine how the proceedings will be conducted. In addition to the Employment Rule 28, the AAA Employment Rule 28, the National Academy of Arbitrators has an opinion that is opinion 26. It's on their website, and it is, given the pandemic, the worldwide pandemic, the opinion basically gives the arbitrator the authority, so we understand, to hold a virtual hearing with balancing all the details of why you need to do a virtual hearing, how long the case has been pending, whether or not parties are being disadvantaged, whether that needs to be done through a full and fair preliminary hearing by the arbitrator in labor cases, for example. And I think the National Academy generally is the labor group as opposed to the employment group. So there are two strong bases for arbitrators to hold virtual hearings. And of course, my view is that the strongest one of those two is Rule 28 of the AAA employment rules. Next slide, please. So the number one issue that both Anne Marie and Heidi have referenced is agreement. The parties need to have agreement, preferably have agreement to the details of how the virtual hearing is going to be held. And that is to make sure that it's suitable and adequate. So each party has to make that determination in their scheduling order. And the scheduling order, the AAA has a model scheduling order that is available on its website. And it is extremely detailed. And as with any other hearing, whether it's in person or whether it's virtual, the issue is making sure that the number one issue is preparation. The number one issue, like little a, is that there's an agreement of the parties. And the scheduling order that the AAA uses as a model has like 6 areas, and I want to go through those 6 areas with you. The hearing record and recordings, i.e. transcripts versus recordings, technical aspects, witnesses and exhibits, hearing schedule and logistics, technical difficulties, and allocation of costs. And I want to go to each of those in order. So the hearing record and recordings, and this is now, these are details that are going to all be found in the scheduling order. And so one of the issues on hearing record is whether there's going to be a court reporter. And the old scheduling orders that just as a one-page scheduling order used to say, is there going to be a court reporter? If there's going to be a court reporter, then there is a transcript, and that transcript becomes a record of the hearing. Not the decision, but the record of the hearing.
Catherine, I've heard a recommendation that we should be using only court reporters that do real-time transcription, because the virtual back and forth can get confusing as to who said what and when. And that's one way that you can make sure you have an accurate record, is having someone there looking at the real time and making sure it's appropriate.
Yep, I totally agree. And I was just in an arbitration as an arbitrator with, I think there were 6 of us, and the record was fully transcribed. So it was real-time transcription, not transcription from the Zoom hearing, the Zoom recording, for example. Then there's the issue of recording, and absent agreement of the parties, then recording is not going to occur. If the parties agree that that you're going to be using Zoom recording, then that's an agreement of the parties. But that also means no recording on telephones, no recording on other recording devices, no screenshots, for example.
Catherine, how do you feel about court reporters recording? Because I've been in situations where, you know, everybody's going around, and my usual court reporter, she records, but she tells everybody right away, I'm recording, it will not be used, it won't be sent anywhere, it's only for me to double check myself. But I've been midway through depositions where I've noticed the recording buttons on, and I found out it was the court reporter, but she hadn't informed everybody she intended to do it. And then she used it as a playback, you know, in ensuring accuracy in the transcript. But if the parties hadn't agreed to a recording, would you allow the court reporter to record?
If the parties don't agree to it, no. If the parties agree that, and that's a question, that's a detailed question that you wind up having to ask.
Yeah.
Are we going to have the transcribe, the court reporter do a recording as they're doing the transcription to be able to deal with that? These are all the details that need to be worked out in advance and clarified in advance so that there's no confusion and there are no surprises. Did that answer your question, Heidi?
Yeah, it did.
And I'm going to interject and say we're really at the end. We have about 1 minute left.
Okay, so with 1 minute left, I would say anyone who wants to see a full detailed order for a virtual hearing, the AAA order is very, very strong and very, very good. And you must have agreement of the parties. You must wind up having all the details that the parties are going to agree to in writing. And once you do that, then a virtual hearing can work. If by chance there is interruption in the hearing because of technical difficulties and it's prolonged, the arbitrator has the authority to determine that the virtual hearing may not work, may reschedule the virtual hearing if the parties agree, or may decide that a virtual hearing won't work because of technology problems and have order an in-person hearing.
Well, I think we are at the end and it's 4:16. I cannot emphasize how much we appreciate Anne Marie, Heidi, and Catherine giving all of us their words of wisdom and comments and feedback just with regards to this new virtual world we're in. Questions, you most certainly can still direct them to Aaron or I, and we can get some answers for you. But we thank you for being part of this session, and we again appreciate everything everybody has contributed to this session, this program.
And thank you for the opportunity. It was really
Thank you.
Absolutely. Thank you again, everybody.